Hi, Michelle. Thanks for joining Real Estate with Caroline. I really appreciate you taking the time to come on and explain title insurance and all the new changes happening in Florida, in challenges and things that come up when we're doing real estate here in South Florida, or all of Florida, actually. So if you want to introduce yourself and, maybe tell everyone who you are, and then we can get started.
Sure. Thanks for having me so much today, Caroline. It's a pleasure being seeing you again in person, sort of today. And well, let's see. I've been an attorney 29 years here in Florida. So working primarily in real estate, probate, and business purchases and sales. So in fact, that's how we met.
Yes. So yeah, definitely we did. We've known each other for quite some time. And I really, again, just want to thank you for coming on and uh, answering these questions. I'll start with the first one I get. We do closings in real estate, and the title company facilitates that. So as a real estate agent, we're filling in the blanks of the contract, and we're, looking at all the timelines for insurance, inspection, mortgages, condo applications, everything that needs to be done on our end. But there's a whole bunch of stuff that's going on the title side. And if you could explain that. And then also, I think what people don't know is, okay, well, what you get title insurance when you're at a title company. And that's pretty important. You're insuring the title, the thing you're purchasing on the house. So if you could explain, because we kind of just hand over the paper and then it's like, I don't know, what are you doing? Doing a lot, I know, but what happens over there?
Yes, absolutely. So once we receive a contract from your office, we review it just like you did as you were carefully preparing it. And filling in the blanks, as you like to say. And so we first, see, verify the parties, verify the property as well, that we're all talking about the same property. We run see if there's a lender involved, so that we know who else, is a part of the transaction. And we order our title search. We start that, and for the title commitment to be able to issue title insurance. And we also run municipal searches so that we can check out any utility liens, code enforcement liens, or open permits. So that's kind of how we get started.
Would it be safe to say you're making sure that the parties involved are the people who supposed to be selling the property, right? And you're ensuring that there's like a clear title? Would that be a good? Okay.
Yes, the first part really of ensuring the clear title is making sure the right parties are on the contract. And sometimes it's unintentional, of course. So for instance, if a property is held in a trust, and it has one name on the deed from, 30 years ago, that trustee might be deceased. And so there might be a successor trustee. So it brings to light that, oh, you have a different name on the contract. Who's the successor trustee? Well, do we have documentation for that? Or perhaps it's an heir or a beneficiary to a will who's named on the contract, and yet we find out the property the estate might not have been probated yet. So it's very important. And also entities. Sometimes different owners own an entity later, or the entity is changed out of a certain owner's name. So we just, really try to make sure before we even order our title that we know that the right party is selling, and so that our documents are correct at closing as to who is actually conveying the property.
And that insurance insures that, like that's what title insurance, is that what that insures? Or?
Yeah, yes. The title insurance is a very, very important aspect of a real estate transaction, and everyone needs title insurance. Attorneys even buy their own, buy title insurance when they're purchasing properties, and that's because you always want to guard your, provide an assurance for yourself and guard against any improper deeds that might have been signed that were forgeries in the past. Could have been 40 years ago and you didn't know, about it. But the property, because maybe it has been insured over time, that creates a title record. And so if the property's been insured, multiple times, then the title insurance company, even if they spot a possible defect from a long time ago, let's just say 30 years ago, 29 years ago, they will often just, allow for the insurance to be written again, because there were so many other policies that were on the same property and sufficient time has passed. But you and I can't make that decision. That would be the title underwriter who makes that decision. So you're guarding against not just, forgeries, but any kind of defective deed. What happens a lot is unintentional legal description errors. And so you always want title insurance to protect you because it's a big investment. You don't want to just have to rely on suing your seller to clear title. You also have another box that you can go to, and that's you have protection through the title insurance policy.
And you would just say, hi, I'm having an issue. I had title insurance, and then they fix it. That's what it's for. Right?
Yes.
But most of the time, you're doing your job up front, and that doesn't happen. But that's the whole reason, right?
Right. We do it up front so that those types of errors are not found in down the road, so that anything that needs to be cleared, for instance, mortgages that have to be paid off in order to provide clear title. Rights of first refusal, that's another one. Estates that have to be probated. Sometimes, on a commercial property, perhaps there's an easement going right through the middle of the whole parcel, but yet there's a building built on the property, or starting to be built, say, and there was not an abandonment of that easement. So there's just all sorts of reasons why title insurance is very important, and it protects your pocketbook, basically, is the bottom line.
That's good. Okay, thank you. Another thing we have, it comes up a lot here in Florida. We touched on probate, which I definitely want to get into. We have a lot of that, but there's another one where I'm probably saying it wrong. I say FIRPTA, and I know it stands for something, but it's basically like if you have an out-of-country owner of a property and it's under a certain dollar amount, they can waive the tax that the I don't want to say foreign, but the foreign person would have
Foreign
to pay.
seller. Yeah.
Yeah.
Foreign seller. Yeah.
So could you explain that? What that is?
Sure. So as part of our real estate contract, it states that buyer and seller will cooperate with each other regarding any, foreign investment in real property tax act issues. And so what this means is generally in the United States, at closing, if there's a foreign national involved, then they can't just sell their property and walk away with all their proceeds. The United States federal government, the IRS, requires us as the closing agents, the closing attorneys, to withhold generally 15% of the gross sale proceeds and send that into the IRS. That's the main rule. And so one way to get sort of around that is if you know way in advance that you're closing, then the seller can apply for what's called it's called a withholding certificate. And what that does is it's kind of a weird name for something that just says, okay, you don't have to withhold the 15%, you can withhold a certain dollar amount because you've proven to us that you've put a lot more money into the property through not just, not decorating and all, but anything that's a fixture that stays with the property, you know, flooring, windows, that kind of thing. So that's one way you can sort of get around the 15%. If you don't have that ready at closing, then another way that that's possible to sort of get around the law is that a seller might say, well, you know, I'm only selling this for under 300,000. Then will you, Mr. or Ms. Buyer, will you sign this affidavit for us? And so it's very common to be presented with an affidavit like that. And what it says is, hey, the buyer, agree that I'm buying this property for under $300,000. And I agree to that. My plans today are such that I plan to reside in the property 50% of the time that the property's in use for the next 2 years, essentially, is what it says. And so if you have a buyer who's willing to sign something like that for you, if it's a very small, you know, condo, then great. Then there is no withholding for that seller, for that foreign seller.
Okay, so I've had this come up, so I'm gonna add like two scenarios. One scenario, like the buyer said, well, okay, I don't have to live here, right? Like, cause it wasn't his primary residence. And I said, no, it's in use. So it just means if you can stay here 2 days, you can stay here 6 months. You know, it doesn't matter. It's just, it doesn't mean you have to stay here more 50% of a calendar year. It just means of the time that it's in use. And then and explain, is that correct? Am I saying that correctly? Like, yes, he can stay for 2 days and the rest of the time it could be vacant, no problem.
It's the regulation talks about it being in the time it's in use. So if you have any, I would say if you have any particular questions about what in use means, then I would, you know, refer someone to their CPA or their, you know, tax attorney, because, you know, it might change on the facts and circumstances what they think is in use, whatever that might mean.
Yeah, that was my other one. I know I did talk to a tax attorney, so I'm happy you're thinking the same thing, because the other one was, he's like, well, I only come for 2 weeks out of the year, but I have 6 kids and they're all going to come for 6 weeks. So how would that work? And, you know, in that instance, it's like, well, you're only here 2 weeks. That's not a title issue or a thing for title. That's a thing for tax, because that's what we're doing. We're waiving the withholding of tax by signing the document. But to get into the technicalities of everybody's situation, that's more of a tax question, but it does come up, and it usually doesn't come up until we're in the title stage. So it's important that we're talking about it now, because if you're a seller considering selling and you know that you're a foreign seller, you have a way to prepare for it. I think what you said is ahead of time through a tax professional, right, Michelle? Instead of even asking the buyer to sign this, right?
Sure.
And if you didn't, and you're like, well, I need to sell, you could still say, well, I could ask the buyer to sign it. But in their instance, you know, I obviously, as the listing agent, have all that in upfront, you know, when somebody's going to look at it, like, this is a foreign seller, they need you to sign this document. So the buyer would know ahead of time. But typically it comes to you, and then there's all these questions. And like you said, you point out they're tax questions more than title, right?
Right. I think that's a very good point. Is, you know, we speak in generalities because we have the, you know, tax provision, but we can't, you know, we don't know every single intricacy in tax. And if it sounds like there are a lot of intricacies in someone's particular situation, then we just ask them to go, you know, speak to their CPA as well about it if they're not comfortable with the actual form of affidavit as it is. And we understand that.
The other one that you really don't know until it happens for a lot of people is probate. You know, we'll have where somebody did have a second home. It was their parents passed away, and now they need to sell a property in Florida. And if there wasn't like a trust or a specific document on how to handle that, it takes some time, and sometimes it can add stress, and sometimes it's a blessing, like, okay, well, a blessing financially, never a blessing that you're losing a family member.
Right,
A
right.
blessing, oh, there's extra money, but then it's oh my gosh, well, the association dues are high and there's a mortgage, and we have to pay all these payments until it gets sold. So this comes up too. You're losing a family member, but now you have to deal with this issue. So could you explain, like, I don't know, if you have a trust or not, or how that would work on your end, if somebody came to you with a closing like this?
Sure. Sure. Yes. Well, fortunately, we know in advance. We ask questions in advance, just like you do when you're going to, list a property, or you're taking sellers or buyers by to view a property. You kind of get the scoop of what's going on to know if there was a death in the family. And so that's why it's important is, we go behind you after you've, prepared your contract. We go looking to see, who is the owner of record, and is that the person who signed the contract? It may or may not be, and the person who signed the contract, has to have authority to sign the contract. Has to be, say, if they're selling it on behalf of an estate, then they have to be appointed by a judge, by a court order, and through letters of administration. Generally, there's other ways. Through if it's there's a summary administration way that a probate is handled as well. So it's important to know what's transpired, and so that helps us to ferret out the rest of what's been transpired. And so if we can help someone also by doing the probate, or doing a summary administration, which generally doesn't take as long, so that the seller can legally sell the property, the heir or the beneficiary. And it's an heir if the decedent had no will, and it's called a beneficiary if the decedent had a will. So just a little terminology there. But so if it's a trust, then we need to see, hey, is the current trustee the same as the trustee that's on the deed? If not, then perhaps the trustee passed away, and we have a successor trustee. So we have to review the trust and then make sure there is successor trustee documentation there. So we're just trying to make sure the right party is signing the right documents at closing, so that the buyer gets the correct documents, and so that title, it can be insured. And another way, though, to maybe avoid probate, or a successor trustee, is if you own the property, husband and wife. Obviously, if you own it, what's called husband and wife status, tenancy by the entireties. Then if one passes, that share goes automatically to the other one, and nothing has to be done with respect to that particular property. It can be sold just by recording a death certificate, if it's husband and wife owned that way. If it's owned by, say, brother, sister, or say two investors who buy something together and don't have a company name like an LLC or something, and they have it two names, like say Caroline and Michelle. If we own property as tenants in common, or if it doesn't say, it's presumed to be tenants in common. And that would mean if I pass away, then my share goes to my heirs. And so you would be dealing with my heirs. But a way to get around that, to provide a more orderly, quicker way for you to handle the property, is if you and I own the property as joint tenants with right of survivorship. And in that case, if I were to pass away, then you get the property automatically. So without paying my heirs. So depending upon whatever circumstance makes sense for you, either a deed, written in one of those fashions, or a trust, or maybe you need probate to get your title clear. So one of those should work.
Okay, so let me, just so I can see if I understood. One, and which is smart, is if you know ahead of time when you're buying property, you can actually talk to the title company and address these, and the way title is held could avoid a lot of things that happen after, that we're talking about in terms of probate. So like you said, if they're husband and wife, or if it's just a couple living together, or two people living together that would like to leave it to each other. Some people might not, your boyfriend and girlfriend, and you say, well, when I pass away, I mean, I want my kids to have my share. I don't want it to just go to you. And then you pass away, it goes to your kids. So those are things that need to be discussed. And if they're just discussed up front when you're buying the property, you can address it in title. But sometimes what happens is that wasn't discussed, and people pass away, and now we have to sell it in probate, and the kids are, splitting it, or if there's one kid, or it just depends on the situation. So when you address it up front, it sounds like it's just a regular closing. It wouldn't take longer.
Exactly.
Right?
It's much faster to address it up front versus leaving yourself with I don't want to say disaster, but with a circumstance where it takes a lot more work and effort and money to resolve.
Right. So the probate, when that happens, and that, because I've had it, and people, they have to pay payments. And what's safe to say? Are they looking at 90 days to close, 6 months to close? Like, what's a good, I don't want to go so long. And I know every situation's different, but if all went smoothly, could they close in 90 days?
I've seen it in 90 days in summary administrations, which means if you own property, the value of the estate is 75,000 or less. And it sounds like, well, gosh, who owns real estate for 75,000? But if the property was already homesteaded, then we get to exempt that from the value of the estate. So we don't count that. So it would really just be the personal belongings and all of that kind of stuff. So that may fit a lot of circumstances. So that 90-day I've seen happen in summary administrations. I would say plan on 6 months. If you don't want to wait 6 months and it's a regular scale formal summary or formal administration, then what I would say is if the will did not have what's called a power of sale in it, then we can petition the court and say, hey, we have this contract and it's fair market value, and here are, Caroline the realtor gave me these comparable sales, it's right in line with all of these, and so we're asking the court to please authorize the sale before the rest of the estate is finalized. And so a lot of times we get the court orders that way. So it all is not lost, all is not lost. Not everything is 90 days, I will say, but oftentimes you can petition the court.
Okay,
And
so I understand that people are paying payments, and sometimes they, their time is of the essence, they're trying to move quickly, but quick in the court,
yes,
that's not happening. Like, that's not, oh, we'll get this done next week in terms of
right.
court stuff. Okay, because sometimes people don't realize that. That's why all of these things are important to address.
Right. And it's, yes, and it's not just, by the way, it's not just because courts are backed up or anything. That's not the sole reason. The other reason is you have to notice the possible creditors. So that could be hospitals, could be mortgage companies, could be, you have to notify them. There's this notification that has to be done, so that to see if there's any claims against the estate. So that's another reason.
Yeah, there's a lot that goes on. So the sooner you start talking to somebody like Michelle in these instances, the better, because it just sets you up quicker for it to happen quicker, whether you're doing it beforehand or you're like, well, too late, I'm stuck in the situation. I wasn't
Right.
thinking of that. I thought, well, I'll deal with all these things and then I'll sell. And then I'm like, oh, wait, this could take a lot longer than I thought it would. So it's always good. They can just, these are things that you can do at your office and make life easier for people. So I
Yes.
hand papers and then you're doing all this stuff. And this is what's going on over there. They're not just sitting at the closing at the last day saying sign the papers. There's a whole bunch of back end stuff happening. So thanks for taking the time to explain all of that, because I don't
Sure.
think
Sure.
and then we also have, there's a new, I don't know, it's just new on the contract. So I thought I'd ask you, it's, I want to say it's less than a year now, but they're adding countries in our Florida contract. Like if you're a buyer from certain countries, can you explain what that new language is in there?
Sure. So I believe Florida is one of 22 states that has passed a law like this, which is to put some restrictions on foreign ownership of real property in our state. And this all kind of started because, some years ago, this Chinese corn milling company was trying to purchase something like 300 acres in South Dakota near one of our Air Force bases where a bunch of drones were always taking off. And so there became questions about, protecting our national secrets and also protecting our food supply. And should we be allowing, as a nation, as a state, so many foreign nationals to purchase all of our property in our farmland as well? So there was a law recently passed last year concerning 7 countries of concern, is what they're called, and to limit their ownership of real estate in Florida. And these include Korea, China, Venezuela, Russia, and 3 others. And so here, let me see, what are the other ones? Oh, Syria and Cuba and Iran. Those are the other ones. And so there are generally, the law is, no buying of agricultural land, and no buying of within 10 miles of a military installation, or another area of critical infrastructure. Could be an airport, seaport, wastewater treatment plant, spaceport, in our state. So it could be any special critical infrastructure facility. And so with China, there is, before China, there is an exception to this rule that says, well, guess what? A person from one of these countries can purchase if they're purchasing only a residence, has to be outside of the 10 miles from the military, base or other critical infrastructure generally. And, can only be used for residence purposes in less than 2 acres. And so China cannot buy any property throughout the state, and except they can have this, one property for residents. So this is, the reason is not to be discriminatory. The reason is because these countries have caused us concern in our national security. And so it's something that is handled by our real estate contract now. And our sellers don't really have to do anything other than sign the contract with this notice on there. And buyers must, if there are foreign nationals from one of these countries, they need to sign an affidavit stating that they're familiar with these laws and they're in compliance with the laws.
100%. So there's an addendum, and that's a separate thing. If they're buying the residential property, their primary residence, that's the addendum.
There's an affidavit. Yes.
Sorry. But there is, just to be clear, there is not one for the agricultural land in the 10 miles. That's separate. I know there's some technical things that could happen, but there's no affidavit now all of a sudden they can buy agricultural land.
Correct. Correct.
So that, right. So there's it's important to know with, you know, when you're selling your home, and, you know, we're a very diverse community here in South Florida, that the realtor and obviously the title company, we have it taken care of. But it has come up because it's just alarming the way it's on one page by itself. And people are saying, well, what is this? What does that mean? Am I responsible? So thank you so much for clearing that up, that it's more the buyer to let people know, and obviously the realtor to let the buyers know, and then the title company checks and makes sure that's happening. That's part of, again, title insurance, right? That goes back to that.
The title insurance doesn't have anything to do with this particular law. Whether the buyer signs this or doesn't sign this it has no bearing on title insurance, is what we've been told by the title underwriters. But it's part of Florida law that anyone who's involved in a sale, basically. And so, yes, I would say both realtors need to make sure, and the closing attorney, you know, need to make sure, if there is a foreign national, that this affidavit is in fact signed. And I, you know, suggest that it's signed at the time of contract and at the time of closing, because no seller or buyer wants to be in contract for 45 days only to find out that the buyer changed his or her mind. It doesn't want to sign an affidavit, you know.
Right. 100%. No, I
We don't
agree.
want to waste anybody's time. We don't want to
Exactly. Another hiccup that could happen, and why it's important to
Yes.
have a good title company and a good realtor, is you don't want all of these things happening in the 9th hour. You think you're going to close, and exactly that. Somebody doesn't want to sign that FIRPTA for the 15%. Somebody doesn't want to sign this addendum if they're a foreign national from one of those countries, or
Right.
sign
Get
it
it done early.
oh,
Yeah. If they don't sign it, you can't sell the property. That's how it goes. Yeah.
yeah, or in the FIRPTA, if the buyer doesn't sign it, then they have to withhold the 15% tax.
Then,
So
yes, then the closing attorney or title company has to withhold the 15% if the buyer refuses to sign that residency certification.
exactly. And that's why it's just important. And I really appreciate you taking the time, because you're busy behind the scenes doing all these things. And I don't think people know really how much work and all the details that are involved on the closing end and what all goes into it. And then to know that there's all these things that could come up that could delay the closing, or have the closing not happen because people aren't aware. You know, you have a lot of people that don't go over this the same way. They aren't held to the standard you hold yourself, or I hold myself. So that's why I really appreciate working with you and you taking the time to explain it. And I know we have to do another show on all the wealth of commercial knowledge that you have, because you also do stuff with the SBA and businesses and people who need financing or closing or 1031 exchanges. There's just so much more that you do. And I didn't want to overwhelm everyone. Say somebody wanted to get in touch with you, how would they go about doing that? You want to, like, maybe tell me one more time, like, everything you do and your contact information? That way I'll put it in the, it's in the description, but just so they have it here too.
Sure. Yeah. Some people might be out of the room and just listening, right? So, sure. My name is Michelle Trca. I have a law office in Fort Lauderdale, and it's called Michelle G. Trca, PA. And we can be reached at, the phone number is 954-467-6711. And by email at michelle@floridaclosings.net, or my legal assistant, which is her email address is legalassistant@floridaclosings.net. So you can reach us that way.
Oh my gosh. Thank you so much, Michelle. I really do appreciate you coming out and taking the time to do this. And if anyone messages me that they want to know when we do the commercial one, that way I'll know. Or if they have any other questions, we can always come back on and do it.
Absolutely. We can go in depth on any particular subject. as need be. So thank you so much for having me on. And I love working with you because you take care of people, which is really nice and refreshing. And yeah, it's nice when you feel that, clients are in good hands.
Yes. Well, thank you, Michelle, and we'll talk soon. I hope you enjoy the day.
Right. Thank you. You too. Bye.
Bye-bye.